Hello and a warm welcome to you this week on The Courthouse. The Courthouse is where we get to learn the law in plain, simple and entertaining language. And this week promises to be very, very exciting. We're going to be talking about a concept or a topic that affects you and I, a topic that affects every citizen all over the world. But first, we'll go on a quick break. Stay with us.
If we have to give you anything, then we have to give you everything. Love Plus Channel 465 is simply the best. Because we have something for every member of the family. So dads, keep the team spirit going on with our intriguing sport highlights and reviews. And moms, cooking is never boring when you have our intriguing drama series. And for all your lovely kids, just sit and enjoy. This, and all this. I told you, we have something for everyone. Because we are indeed all about you. So keep it locked on Love Plus Channel 465 on Star Times.
You're welcome back. This week I said we're going to be talking about something that affects you and I, and it's about the workers. In every society, workers are the driving force. They are the engine of every society, and no economy all over the world can survive without workers. Therefore, workers should be treated specially. So this week, our topic is rights of employees, rights of workers. And as usual, I'm joined by a seasoned legal practitioner. He's based in Nigeria. He is Joseph Elvis Esosa, and he is the principal partner of YZF Partners, a legal and HR firm. You're welcome to the courthouse.
Thank you very much.
So workers, first of all, we hear of employees and all that under the labor law, under the Labor Act and different laws. First of all, who is an employee?
An employee is one who works for an organization.
So it's right to say an employee is a worker? An
employee is a worker.
Okay.
So whether he works for the public sector, or works in the public sector, or works in the private sector, he is a worker. He, at the end of the month, or at the end of the week, or day, as the case may be, he's paid some salary, then he's a worker.
Okay, so are there categories of workers or employees under the Labor Act or various laws?
Well, under the Labor Act, the law actually says, just talks about employees, all right? But the Labor Act distinguishes between workers and non-workers, so to speak, under the law. All right? So whether you work or you don't work, whether you are considered a worker or a non-worker, you are an employee of that organization. Now, this is how it is defined. The worker are those who do manual labor and clerical works. But those who offer technical, professional part of the service, they are not considered, they are considered as non-workers.
Non-workers.
All right? So, but they are employees. So the idea of worker is actually like basic labor.
Oh, okay.
So to speak, yes.
So these two broad categories make up the employee? Or
yes, make up the employee, yes.
Okay. So now, what are the rights? Because we hear of benefits, we hear of rights. We need to know the rights, the basic rights of a, should I not say employee?
Yes, employee.
Okay. So the basic rights of an employee.
All right. First and foremost, if you are an employee, you are entitled to be paid. Okay. You are entitled to be paid the minimum wage, whatever that is. So, for example, in Nigeria, we talk about minimum wage at federal level, and that's
so much,
you know, that's causing all of that argument. So, you have a right to be paid, to be paid what your minimum wage is, and then you have a right not just to be paid, because people can be paid anyway, anyhow, all right? But you must be paid properly, like paid in monetary form. Okay. And in whatever manner you are paid, it must be legal tender. So you don't pay, for example, in dollars in Nigeria, even though there are exceptions to those rules, as you know, as it affects the expatriates, and you know. But however, you must be paid in the currency that is legal tender, that is acceptable in the land. And then you can't, by the Nigerian law, the labor law, you also cannot pay somebody with goods and services in return.
Trade by barter.
Yes, so it's not trade by barter. So you have to pay by that remuneration that is calculable in monetary form.
Okay, quite interesting. So are there other rights?
Yeah, there are other rights. I mean, for example, too, you have a right to certain hours of work in a day. Now, your agreement will say you would work for 6 hours or 8 hours in a day. You have a right to an accumulation of a break that is not less than 1 hour. So if you work for up to 6 hours, you have a right to have a break, whether it's 10 minutes break, 20 minutes break, but the accumulation of all of those breaks should not be anything less than an hour. So if you work today, you are an employee somewhere, and you don't have up to 1 hour break, then your right is being infringed. So you have a right to have a break for up to 1 hour.
Okay, so certain cases, you just talked about the right being infringed if you're not having a break up to 1 hour, so I don't want to go there. But there are certain cases where people are employed and you see a very large volume of documents given to them as conditions or service and all that, and the person is wondering, how long will it take me to go through these documents? Like a colleague just told me about a friend that had this volume of book that's supposed to be like conditions of service, and the person is wondering, when will I ever go through this? So can you throw light on that? Does that really happen? And is it okay?
Unfortunately, the law merely says that once you are engaged as an employer, within 3 months of your getting that employment, you should be given an employment contract. Okay. Now, the employment contract is something else. It can be voluminous, like you said, and there are a lot of people who are unable to read their employment contracts and understand it. Even though it is said that it is an employment contract and that you, who is the employee, is supposed to be able to negotiate the terms, in practice, terms are really not negotiated. They are more like imposed. So you just append your signature, and especially in a situation that we have in this country where somebody is ready to take 1/4 of the pay. So you don't even bother to do all the reading. But you see, at the end of the day, it's at your own expense.
Okay.
Because by the time the terms and conditions are unread by you and you start breaching them, it will be a ground for dismissal.
For dismissal, and yes, you cannot really protest.
And then, of course, you can do all the shouting that you want, but there's a document that you have signed that regulates what your terms of employment is. Yes.
Interesting. Therefore, it's advisable that you read through every single
Very
term,
advisable. As a matter of fact,
condition.
you should get a lawyer to read through it,
yes,
and then get back to the company whether you really want to work with them and negotiate your terms.
Because that's actually the purpose of this show. We talk to people to enlighten them on their rights so that they get to know. You don't just sign any document. You have to go through it.
You have to go through it.
And they have to, of course, get a lawyer.
Very important.
So I'm going to ask this question because it seems you just mentioned the fact that in a situation where there's very few jobs, there's scarcity of jobs, you have to do...
Yeah, people just end up accepting anything.
You have to accept any condition.
On, yeah.
Okay, I'll hold these thoughts. After the break, we'll go to this question. So you've been listening to Elvis Esosa, and he's been talking about rights of employees. We have a report on this topic and our legal nuggets. We'll be right back. Stay with us. Under the Nigerian Labour Act, there are certain minimum obligations every employer needs to meet. These obligations are as follows. 1. All employers must provide their employee with a written contract of employment within 3 months of hiring the employee, and there are certain essential clauses which must be included in the contract. 2. All employers must conduct a medical examination of every employee before the employee commences work. The examination must be carried out by a registered medical practitioner at the expense of the employer. 3. Employers are obligated to provide rest breaks of at least 1 hour for every 6 hours of work and must ensure that in every 7 days of work, employees will be given at least 1 day of rest, which shall not be less than 24 consecutive hours. 4.
Generally, women are prohibited from night work. However, the Labour Act allows for some exceptions. Further, Nigerian female employees who are pregnant are entitled to 12 weeks of maternity leave, 6 weeks before the due date and 6 weeks after. And where she has been in employment for at least 6 months, she is entitled to at least 50% pay during her period of maternity leave. 5. All employers must give their employees at least 6 working days of holiday with full pay for a 12-month continuous service period. Further, employees are allowed to take up to 12 days as sick leave in any 1-year period, provided that the absence from work is certified by a registered medical practitioner. Please note, however, that the Labour Act does not apply to all classes of employees, and therefore you need to consider if your class of employment falls under the Labour Act to ensure whether the above obligations apply to your sector.
You're welcome back. If you just joined us, this is the Courthouse, and this week we are talking about rights of employees. Employees are a special category of people in the society, and their welfare should be paramount. So that is the focus this week. And we have Elvis Esosa. He's a legal practitioner, and he's been giving us some rights of employees. And before we go into more rights, let me just ask you, these rules you're talking about, is it applicable in the private sector as well?
Yes, very well. It applies to both private sector. As long as you are an employee in Nigeria, it applies to you.
It applies to you.
Yes.
Okay. Now, other rights and let's say other rights of the employees, like maternity leave, which we are going to mention earlier. How many months is a private sector worker entitled to, and how many months is a public sector worker entitled to?
Okay, the law is very clear on what the employee who is pregnant is entitled to. You are, as a pregnant woman who works in an office, whether you work for the government or you work for the private sector, you are entitled to, in total, 12 weeks, of maternity leave. 6 weeks prior to when you give birth, and then 6 weeks after you give birth. However, in practice, employers usually make it flexible and allow mothers or nursing mothers or pregnant women to observe these 12 weeks at their own convenience. So, for example, a woman may work until she is 1 week before the due date, so that after she gives birth, she has 5 more weeks. So the entire period is a period of 12 weeks, 6 before and 6 after. But however, they just make it flexible. There are some other organizations who do not give up to that time, that period of time. They're in breach of the law. And then, you know, an employee can actually take that up to say the law requires that I have some 12 weeks.
12 weeks, that's 3 months.
Yes, to stay away from work. And then while you are observing your maternity leave, you're supposed to be paid. Full payment for the period.
With all your bonuses and
yes,
all that.
Everything that accrues to you, you're supposed to get. However, if the person has done, say, about 6 months in the place where the person is working, she's entitled to 50% of what is due her as salary at the end of the month for the period. And then for some people,
the men?
Yes, exactly. Paternity leave. Well, the Labour Act does not recognize any paternity leave, does not make room, does not create the right to a paternity leave. However, 2 states, Enugu and Lagos State, have taken the bull by the horn to grant paternity leave. And in Lagos State, it's for 2 weeks, which is 10 working days. Okay. In Enugu, it's for 3 weeks.
Okay,
and then in Lagos, it's for the, I think for both, it's for the first 2 children that you have.
First 2 children.
Yeah, and
so
that leave must be taken within the first 2 months when you have them. So if you have the 3rd child, well, you're on your own.
Okay, that's quite interesting. Yes. So now, are there other rights? Like, you're talking about leave now. I want to go on a study leave. Am I entitled? Do I have the right under the Labour Act?
Not necessarily under the Labour Act. That's more like an arrangement between you and your employer. In the civil service, they have rules that guide your study leave. You ought to have worked a number of years, and then and then it varies from whether it's a local government, state government, or federal government. They have their rules. For the private business, your employer must love you so much and have a lot of respect for you to allow you go on study leave and then pay you. Otherwise,
But what if your employer agrees that you can go on study leave and before you know it,
except it's in your contract. If it's in your contract that you can go on study leave, then why not? You can go on study leave. But
what if you're not asking for pay now and you get terminated while you are in your study leave, for instance?
The question is, did they ask you, did they grant you the study leave in the first place?
Okay, so there must be...
Yes, they must grant you the study leave. There must be a prior grant. That's like a permission to say, okay, go and study. When you are done, you can come back. Okay.
Then now we're talking about termination and all that. What constitutes a proper discharge or a proper dismissal? Because we get to hear that in private sectors they can hire and fire and all that.
Okay.
But what constitutes a proper dismissal?
Okay, generally under the law, dismissal and termination are 2 different things.
Okay, so let us know. That's why we're here.
Dismissal and termination are 2 different things. An employee is dismissed for misconduct.
Okay.
But however, an employee's contract can be terminated, and in every contractual arrangement for employment, there is a period that is given as a notice period. By the law, the labor law, if you have worked in an organization for, say, 0 to 3 months, between 0 and 3 months, you need a 1-day notice to be fired. And you also need a 1-day notice to your employer to leave, to disengage yourself from the employment. Now, if you have done between 3 years and 2 years, then you have 1 week notice between both parties. If you have done between 2 years and 5 years, you have 2 weeks notice between both parties. If you have done 5 years and above, then you need the 1 month notice, or else salaries will be paid either way in lieu of that 1 month notice. Yes.
Okay, so now this, I think the law says in some points that there are some of these categories that need not be in writing. So which category should be in writing?
And which should not be in writing? Okay. Once the notice, it's a 1 week notice or more than a 1 week notice, it has to be in writing. If it's less than a 1 week notice, then it doesn't necessarily need to be in writing. So that means that if you want to fire a person who you have engaged in that employment and he has done 0 to 3 months, you need 1 day's notice, and it may not be in writing. You just call the person and tell the person. You also, who is the employer or who is the employee, you can also give your employer the same notice. You can just let him know verbally. But if it's a situation where you require a 1 week notice or more, then it has to be in writing.
Okay, very interesting. So now, now that you've talked about the discharge and dismissal, you've helped us to understand that dismissal is for misconduct.
Yes.
While a discharge, a termination is different.
Yes, it's different.
And that's the one that requires notice.
Notice, exactly.
Okay, so what more can you tell us? If an employee is unjustly discharged or dismissed, what are the remedies available?
If an employee feels
yes, not subjective.
If an employee feels that he's been unjustly discharged, dismissed from work, he can bring an action against his employer. First of all, I mean, we talk about alternative dispute resolution. You can reason with your employer If he's not listening to you, then you can go to court. Not just any court, but it has to be the National Industrial Court of Nigeria. Yes, that's the court that is saddled with this responsibility. So you can go there and then make a case, make your claim, and then the courts can do either of two things. They can decide that they can refer your matter to the ADRO center within the court premises, so you go and resolve there. If you are unable to resolve, and usually I think it's about 20 to 21 working days that they give. If the matter is not resolved, they may also extend for another 10 working days. If the matter is still not resolved, then it has to go through the normal court process.
So
yes.
Quite interesting. So
to
is there any question we have not asked you? Is there something
let me just add that there are various remedies that you can ask for when you go to the industrial court. You could ask that you be reinstated, as in get back to work. You could also ask for terminal benefits to be paid to you in accordance with your contract, and any other benefit that accrues to you that is unpaid before the termination or before the dismissal.
Okay, we will need to clarify that. When the person is dismissed or terminated and you have accrued benefits, are you entitled to get those benefits?
You are very entitled to it. So, for example, if your employer is owing you 4 months, and some allowances, and your appointment is terminated, he has to pay. So those are things you can ask for. You can also ask for monetary compensation to say, for wrongful termination, this is what I have incurred and all of that, and the courts can also award damages too.
Quite interesting.
Yeah.
Okay, we've come to the end of this segment, but I informed you before we started I would have another segment.
Okay.
The bar book. So it's not like I'm setting you up or anything. So what's your favorite Latin maxim for the week?
Okay, I will take this one. It is called quid plantator
solo
sedit.
Okay. So you have to tell us the meaning.
Yes, that means that whoever owns the land owns what is on the land.
Up to the high heaven.
Yes.
Okay,
so if you decide to go and build on another man's landed property, you have just helped him to develop his property, and he can smile home or move into the apartment and live.
That's quite interesting. So this week I'll stick with Ab Irato. That's a man that is angry. So stay away from angry people. You get to find out more Latin maxims on our bar book segment. Stay with us. Welcome back. We have another segment where we treat questions that come in from our viewers. That is our question and answer segment, Ask the Law. And we have our legal experts standing by to provide answers to those questions that you sent in. Take a listen.
There is no rule. The landlord can increase rent anytime. But generally, it is better that the normal thing is that some landlords increase their rents every year, some every 2 years, some every 4 years. but generally it is not lower than yearly, some 2 years, some 4 years, and of course the maximum is 5 years. And fairness, again, taking the economic situation into consideration. You know that prices jump up regularly, so the landlord too want to prorate or look at if rent vis-a-vis the economic situation.
You're welcome back. I hope you found that answer quite interesting and helpful. We still have Elvis Esosa, but it's time to go. So we must say thank you for making our time to be with us this week on the Courthouse.
My pleasure.
And we'd really like to have you some other time.
My pleasure.
Well, okay, that's what you can take this week on the Courthouse. If you have comments for us, you want updates, you can log on to our website on www.loverplus.tv. I am Itohan Olomu-Agbodo, and I say, don't just get mad, go get a lawyer. Bye for now.